Good morning, everyone. We're going to start our presentation now, and on behalf of the Leinoff and Lemos law firm, as well as MBAF, we'd like to welcome you to today's discussion about marital dissolution trends and considerations. My name is Marta, Alfonso, and I have the pleasure of introducing this great panel. And I'm going to start with Natalie Lemos. She practices exclusively in the area of marital and family law, and she's been board certified since 2002. She's a member of the American Academy of Matrimonial Lawyers and the International Academy of Family Lawyers. She's also the immediate past president of the Florida AAML. She's been named one of the best lawyers in America since 2006, as well as a Super Lawyers, South Florida's top lawyers and Florida Trends Legal Elite. She's co-authored articles for the Family Advocate, and she graduated from the University of Pennsylvania Law School. So we welcome her today, Natalie, who is a distinguished panelist, and she's actually been on the news in South Florida. It's been exciting to see her there talking about trends and marital issues. Our next panelist is Tami Clemenza. She's a principal in the Management Advisory Services Department and is the head of the marital dissolution practice of the firm. She began her career back in 1988 and brings with her Big Four experience, and she's been working in the forensic accounting arena for the past 25 years. And her specialty is in complex financial forensic issues with respect to matrimonial cases. And it's always hard to introduce yourself, so I'll do my best. I'm Marta Alfonso. I'm the head of litigation for MBAF. I, like Tami, participate in matrimonial cases and am also in financial forensics. So want to welcome the three panelists. And with that, I turn it over to Natalie.
Thank you so much, Marta, and thank you for inviting me to join you and Tami in making this presentation today. So we're going to try to do sort of a nuts and bolts on family law, the trends in family law, and the tax implications and other financial aspects of family law. And let's look at the overview. We're going to try to hit these topics, and I'm hesitating because I've given lectures for an hour on just one of these topics. So we're really going to try to condense it and give you little tidbits on each and foundational information. But if you need anything more expansive, I strongly urge you to consult with a family law attorney and also a forensic accountant who's familiar with family law. So we're going to touch on agreements. There's prenuptial, postnuptial, and marital settlement agreements. We're going to go over roughly what the elements of a divorce are, including equitable distribution, which is the mamma jamma, the big issue in divorce cases and where you start. We're going to talk about tax returns before, during, and after a divorce. We're going to touch on support issues, and we're going to hit issues of professional fees and how to protect yourself. Okay, so let's talk about agreements. Courts in Florida look to enforce agreements. They want to see contracts upheld. They are looking to make sure that the integrity of the process is preserved. But if an agreement is entered into with the proper elements of financial disclosure, or in certain circumstances, waiver of financial disclosure, something that is conscionable, with both parties having their eyes open, the courts are going to look to enforce those types of agreements. Florida became a signatory to the Uniform Premarital Agreement Act in 2007. This is pretty uniform throughout the country. Not every jurisdiction, but most abide by the UPAA. And generally what you want to look for is disclosure of financial information. You're going to try to get timing, completeness, and accuracy of financial disclosure. You're going to consider other financial issues, like is insurance an issue, or estate planning may be an issue. Ideally, you're going to want to have a personal financial statement that's as accurate as possible. What I would also recommend is conferring with, if you're the accountant, conferring with the lawyer and vice versa, so that the agreement itself will say, there have been no recent business valuations. This is predicated on estimates. Maybe there have been recent appraisals or not. But if the disclosure sets forth the methodology used, you can avoid problems down the road. At the signing of the document, you may want to have a videotaping or a Zoom taping. And you also may want to consider attaching some of the financial disclosure to the agreement itself. If you're representing young people that have small tax returns, you can attach the tax returns to the financial, to the ultimate agreement. When you're representing older adults that may have more complicated finances, it's not practical to attach hundreds of pages of documents to the prenuptial agreement. One of the audience members pre-submitted a question, and the question is, what are the requirements in preparing a non-contestable prenuptial to protect your existing assets without it being overturned or some loophole being used? So, you know, lawyers love the word loophole because we don't intentionally create loopholes. We are, when we're drafting an agreement, trying to get a document as tight as possible. But as anybody who's got any business experience knows, you can always be sued about something. Whether the lawsuit will survive or be successful is another matter. But generally speaking, we're going to go to the next slide, which is going to talk about the ideal circumstances. And that's going to give you a good guideline of what you want to see in place with a prenuptial agreement that will kind of make it as impenetrable or as invulnerable as possible. So ideally, what you want to see, Marta, if you can go to the next slide. Ideally, what you want to see is the discussion of an agreement happens well before the wedding date is even set. We would like that no one is pregnant, so that there isn't a claim that if we didn't get married, my child would be born out of wedlock, even though that is not necessarily a defense to an agreement. We would like everyone to have settled immigration status, ideally US citizens or US residents. If someone's here on a temporary basis and they're going to be forced to leave the country, that could create a situation that is not ideal for the execution of an agreement. We would like full and complete financial disclosure. The draft agreement should be provided early in the process. So even if the parties talk about an agreement months in advance, but the agreement is provided, you know, a week before the wedding, that is not an ideal circumstance. Both parties ideally should have their own independent lawyers. The agreement should be negotiated over a period of time it's not a take it or leave it when it's presented, but the agreement is presented and then there's some negotiation about some of the terms, and that the agreement is ultimately signed well in advance of invitations being sent out to a wedding. I will tell you, after practicing law for over 30 years, it's very rare that you get all of these ideal circumstances met, but listen, we can always aspire to the ideal. So postnuptial agreements are a different animal for the most part. Sometimes people will do postnuptial agreements when they weren't able to complete the prenuptial agreement sufficiently in advance or with the right financial disclosure, or there may have been some hiccup with the prenup. So shortly after the parties get married, there may be an exchange of financial disclosure and a postnuptial agreement may be entered to replace essentially a prenuptial agreement. Oftentimes, people will also do postnuptial agreements when there is what I will call a triggering event. So the triggering event could be somebody stands to inherit a substantial amount of money later on in a marriage, and they want to carve out that inheritance. Somebody may be entering retirement age. And when they hit retirement, one party may say, you know what, I'd love to use my entire pension to invest in the Avon new products that they're coming out with. And the other spouse may say, whoa, you know, this pension was accumulated during our marriage, and even though it's in your name, I'm not on board with that. So they may agree to carve out with a postnuptial agreement what the investments are that they're going to do. They may separate some assets. And in a postnuptial agreement, you can have it become effective immediately. For example, I immediately am going to take ownership as my separate property of real estate. Or it could be something that goes into effect down the road. In the event the parties divorce, they've essentially pre-planned their division of assets and other considerations. The postnuptial agreement needs full and complete financial disclosure to be effective. Okay, and some more in postnuptial agreements. It is not construed under the Uniform Premarital Agreement Act. So postnuptial agreements are governed by case law. The old case of Casto versus Casto, that governs the steps that one would have to go through if you were looking to try to set aside a postnuptial agreement. So the elements are set forth on your slide about the initial determination. If it hasn't been entered into under fraud, duress, coercion, misrepresentation, then the agreement is not going to be set aside. The next step would be, is the agreement unconscionable? And that, I say that that's like pornography kind of, or obscenity. You know it when you see it, but it's hard to define that because it's so fact specific and circumstantial. But if it is found to be unconscionable by a judge, then the next element would be, was there adequate financial disclosure? And if the answer is yes, game over, that agreement is going to be enforced. There's a recent case of Stefanos that just came out of the 4th DCA, and you'll see the citation on your slide. And in that case, the appellate court found that a postnuptial agreement was entered into between the parties. It's not the same thing as a marital settlement agreement. The postnuptial agreement was entered into to determine certain financial rights at a time that the parties were not going through an irretrievable breakdown. So there was no divorce on the immediate horizon. There were a number of executory provisions in the postnuptial agreement. What that means is we've got an agreement that says in the future, we are going to do X, Y, and Z, those executory provisions. And the appellate court reversed the trial court and found that those executory provisions were still enforceable because this was a postnuptial agreement and not a marital settlement agreement.
Thank you, Natalie. And now it's time for the first polling question. How many clients do you work with on pre or post nuptials per year? None, 1 to 5, 5 to 10, more than 10, or not applicable? We'll give you some time to answer.
We'd ask you to complete these questions because this session is getting 1.5 CPE credits for those that need it. So your participation is important. And besides, we want to know.
And it looks like the majority is none. And with coming in second is 1 to 5. And the last one is not applicable. So
I do think though that once people get educated on the value of them, even if ultimately they decide they don't need to sign one, the process of actually going through and having the discussions about those issues may save a lot of angst after you get married. So it's worth doing anyway.
So marital settlement agreements is really the document that most professionals are accustomed to. And a marital settlement agreement is typically entered into when the parties are going through a divorce, after there's been an exchange of financial disclosure, there may be depositions and other discovery that's been taken. And once the marital settlement agreement is signed, it can really only be challenged for mistake or even fraud within 1 year of its execution. The only exception to that is a fraudulent financial affidavit. And if there is a claim of a fraudulent financial affidavit, then it is not time barred. There is no time limitation on that. The beauty of a marital settlement agreement is it allows you to put in provisions that a judge could not do at a final hearing. And some of the provisions are listed there on your presentation. For example, security for an equalizer payment or collateral. You can't get that when you go to a final hearing, but you can get it in a marital settlement agreement. I would also point out to you that the importance of a financial affidavit can't be understated. So very typically a financial affidavit is done early in the process. And more often than not, if your client is the wage earner, they have a tendency to try to underreport their income. And during the course of discovery, it may be adduced that there is additional income or the income is greater than was initially presented on the financial affidavit. Because the financial affidavit sets the benchmark for any subsequent modification of support, child support or alimony, you really want to take a good look at the financial affidavit that is in the file, so to speak, at the time of the marital settlement agreement and consider updating it. Because if you have underreported income on a financial affidavit, that does not help your client down the road with a modification, because the support that they've negotiated to pay is probably based on higher income. So it's to their benefit that the documented financial affidavit is consistent with the income numbers that are used in the marital settlement agreement. And that's a practice point that many professionals overlook.
So one area we often encounter in a divorce is whether an asset is a non-marital or marital asset. This is the issue where commingling comes up and we are determining who owns the asset and if the character of the asset gets commingled or converted. So the burden of proof is on the spouse claiming the non-marital component. For example, a pre-existing brokerage account or an inherited brokerage account that a spouse brought into the marriage, it's their burden to prove that that account was not tainted or commingled. So this is where we come in as forensic accountants, and we spend time tracing every transaction from the date of marriage to the date of petition to prove that the account stayed intact according to Florida law. Now, having withdrawals out of that brokerage account does not convert the nature from a non-marital to a marital. But however, if you're going to be depositing your wages in there and earnings during the marriage, that would convert it and you could be in some trouble. So it's very important to maybe consult with a family law attorney prior to getting married as to, or when you're inheriting, what steps you should take as to preserve it. And Natalie, what are some of the legal issues involved with the commingling?
Okay, so real estate is easy, right? The effect of jointly titled real estate under Florida law has been well settled for a very long time. And that's the Robertson case, which is a Florida Supreme Court case. And that case says when a spouse takes their non-marital property, real property, and they add their spouse to that real property, the law presumes that they're gifting 1/2 of the value of that property to their spouse. When it comes to personal property, including bank accounts, there is not the same presumption. So the effect of jointly titling a non-marital account does not presumptively convert it into a marital account. And you'll see, I gave you some case law for you to look at because some of these cases really do a deep dive into the account was opened before the marriage and then a spouse added. That's the Geico case. And in that case, it was not found to have been converted into a marital asset. Then you've got the Jan case where there were all kinds of accounts, some created during the marriage with non-marital funds. Some did not have the spouse added, so it stayed in the name of only one party. And what the court articulated in these cases is you want to look at a number of factors to determine whether there has been commingling or not. We want to look at the title to the account. We want to look at whether the account appreciated during the marriage. And if so, what was the cause of appreciation? We want to look at who was controlling the account. So did the out spouse, right, the spouse that did not initially hold title to the account, for example, did they ever exercise control out of the account? Were they able to write checks and disperse monies? We also want to look at the length of the marriage. Most of the cases where you've got reported opinions deal with these very short-term marriages, right? Parties get together, one spouse takes their non-marital and plunks the other spouse's name on the account. It seems inequitable to then to determine that the entire account would have been deemed marital. And then we also want to look at intent. So these factors all become relevant when it comes to personal property, bank accounts, brokerage accounts, unlike real estate, which the court treats completely differently. Okay, so when I talk about equitable distribution, there's 4 steps that if you abide by these 4 steps, you can always kind of navigate your way through the right analysis. And the 4 steps for any asset and liability when you're looking at a divorce situation is to identify it, then you classify it, you value it, and you distribute it. Identify means Is it an asset or a liability? Even if it's contingent, whether it's marital or not, that would go to classification. But capturing the universe of assets and liabilities is the identification process. The classification process is it marital or non-marital? And it may be a combination of both. We're going to address issues of valuation. How do you value these different assets and liabilities? And finally, what are some strategies to distribution?
So from the court's perspective and from the marital estate's perspective, that identification involves you really going in and understanding all assets and all liabilities, whether they exist or they're contingent. You're going to classify them into marital versus non-marital. Traditional ones that we see are things like prepaid taxes that people sometimes forget, unpaid taxes because they haven't gotten to the end of the year to file their return, or they've done an extension, they know they've got to pay. There are tax attributes that are relevant, such as loss carry forwards, benefits with respect to executive compensation in accrued vacation, or other types of reimbursement plans, stock options, SERPs. And in today's world, we have more and more people not only using traditional banking institutions, but they use cash apps and they have cryptocurrency. So places where they're not going to have traditional custodians to provide information. So in this classification process, to make the determination of marital versus non-marital, the question of when it was acquired, in what manner was acquired, again, the issue of tracing comes up here. Did that value appreciate, and what was the cause of the appreciation? Was it active appreciation due to contributions from assets in the marital estate, or was it passive due to just merely the passage of time in the market? And Tami will talk a little bit more about that. And again, this listing and determination is made as of the date of filing.
So there are two types of appreciation. There's active and passive. One example of active appreciation is where one spouse is working in a business and due to their labor during the marriage, the business increases in value. I'm going to give you an example of a brokerage account in both passive and active. So with a brokerage account where one spouse actively trades the account, and that's basically their job. I've seen this in a couple of cases where they're buy, sell, buy, sell, buy, sell. That could be deemed active appreciation as well as passive. It could be a hybrid. And with the same scenario with a brokerage account, which you have a wealth management advisor, you're paying them a fee and they're buying and selling and you have no control over what is being bought, what's being sold, and the market, the value goes up or down, that's considered passive. So, because the market fluctuations are beyond any party's control. The new deals with real property that one comes into a marriage with, on CAW, which is now Florida Statute 61.075, the site is there, deals with when one party comes into a marriage with a house that they own, maybe with a mortgage, maybe with not, but yet during the marriage, they use marital funds to increase the value. So how do you break out the non-marital and marital component, considering the one spouse has the house deeded in their name and the mortgage is in their name, but yet during the marriage, marital funds and efforts are being used. And on the next slide, I'm going to walk you through a very high level calculation of the CAW, or not the CAW, the Florida statute calculation. So in this situation, in our scenario here, one spouse comes into the marriage with a house worth $500,000 at the date of marriage. There was $400,000 of debt. At the time they file for divorce, it is worth now 900 and the debt is 200. So the equity is 700. But during the marriage, they paid down the mortgage with marital funds of $200,000. They also used $100,000 of improvements to the property with marital funds, which may or may not have enhanced the value of the property. Then also there's a passive appreciation due to time and due to market, which is the $300,000 in the lower box. Now that's where the coverture calculation comes in, according to the 61.07 that site in the last slide, and how you calculate that allocation. So basically the general thing is you take the pay down on debt divided by the fair market value of the marriage, which is the 500,000, and you come up with a percentage, and that percentage then gets allocated to the passive appreciation. So in this situation, on our equitable distribution schedule, we would have the house valued at 700,000 in equity. The non-marital portion would be 280, and the marital portion would be 420, which would be split 50-50 between both parties.
So in talking about equitable distribution, you also want to look for potential pitfalls and problems and think outside the box. For example, you may find out, and this is very typical in South Florida, that a party has been put on title to real estate by parents. Now, they may say to you, oh, my parents did that for estate planning purposes, but it's incumbent upon you to verify the information. You want to make sure that if they're asserting that it's non-marital, that there has been no payment made to acquire an interest, that there has been no contribution of marital funds to maintain the property or improve the property. And if you determine that there is a marital component to it, you may want to consider adding the other title holders to the litigation if ultimately you're going to be asking the court to order the sale of the property or to somehow impact that particular property. Similar to trusts, trusts may need to be added to the litigation. Under Florida law, a trust, just like an LLC or a corporation, is treated as a separate entity. And when I say trust, I mean an irrevocable trust. And because of that, to the extent that there may be marital assets that were improperly transferred into a trust, in order for the court to have the possibility of exercising jurisdiction, the trust must be added as a third party to the litigation. It's also important to consider issues about the immigration or international status. And Marta, can you speak to that?
Certainly. It's important to note that if you are dealing with one of the parties being a non-resident in connection with the marital dissolution, that an otherwise separation or division of assets that would be considered not taxable by the Internal Revenue Service will actually change its character and it will become taxable. So it's really important that you have not only an understanding or a general idea, but that you visually look at documents to support the status of each individual to make sure that there are no issues with respect to residency for purposes of tax treatment.
And
Now,
the only thing that I would add before we go on to trust is when you are creating your equitable distribution chart, I would say that the greater the disclosure, to a certain extent, the better. And the reason why I say that is very typically we'll have an equitable distribution chart that will have a number of bank accounts that have nothing in them. I think it's the better practice to include all of that data on your final equitable distribution chart, even if it's with zero balances, so that in 2 years from now, when the client goes to a new lawyer or a new accountant and they forget that there was discussion about those accounts, nothing appears on the equitable distribution chart. This gives you the protection that all of these assets were looked, felt, and touched by you, and determinations made on the lack of value, rather than deleting them and having them not appear on your final equitable distribution chart. So I think it's really important that you try to capture the universe, because that protects everybody down the road.
And I'm going to add one more thing on that, Natalie. And sometimes we put closed. The account was closed on such and such a date. We do list it, but that way maybe refreshes that person's memory.
I think in addition to that, we have seen people put the assets that are in their children's names so that there's no questions about those accounts as well. So I think erring on the side, even credit cards, erring on the side of more disclosure is better. I agree with that. So let's talk a little bit about trusts. As Natalie raised, an irrevocable trust is an animal that is typically not part of the marital estate. And if you've got to take out assets from that trust that weren't appropriately included, you've got to add them as a party. Revocable trusts, generally for estate planning purposes, are included in the estate. There's always a discussion about whether it's marital or not. I have never had a situation where trusts aren't an issue. I would caution those individuals that don't get the legal documents with respect to a trust, just relying on a representation that it's revocable or irrevocable. You really need to see the documents. The source of the assets, how they've gotten in, and what the transfers were. And again, Natalie raised that. When they were created, who has control? Are there beneficiaries, and do the beneficiaries have control?
So when are assets valued? In most cases, we value the assets and liabilities as of the date of filing. However, the judges have discretion to change the valuation date based on certain circumstances. For example, if one spouse works solely in the business and they file for divorce, and after that filing of divorce, they are continuing to work in the business using their post-filing efforts in labor, and the value of the business increases. Why would the non-owner spouse benefit from that increase in value? So that would be an argument that would be made to use a date of filing, because it would really be inequitable to the non-owner spouse to reap any benefits that they would not be entitled to. With regard to like a 401k, the date of filing is theoretically the cutoff, but what happens when you're contributing your 401k contributions afterwards? So we need to carve those out, because those are technically non-marital contributions, and we carve those out. And then we also calculate the market fluctuation on both the non-marital and marital portion, the non-marital being the contributions. And then when we present it on the ED, Equitable Distribution chart, we put the total value of the 401k at the current value. And then we carve out the non-marital, which would be the contributions and any increases or decreases due to market fluctuation. And then the balance being the marital portion divided by 50-50, because that's the law in Florida. So, but there's one big issue going on in today's world, as we all know, which is the pandemic of COVID-19. So what happens when you have a business that due to the pandemic and today's environment goes down in value? Or in the alternative, what happens if it goes up in value? This would be a point of contention for the lawyers to argue what would be the best date evaluation to value that business.
So on equitable distribution, we've touched on some of these issues already. We want to make sure you capture and look for also contingent assets and liabilities. And one of the points that Marta and I wanted to bring to your attention is the issue of tax affecting and being mindful of tax issues that are attributable to specific assets. And Marta, do you want to address that?
Yes. Sometimes in negotiations, people will try to offer non-cash, what I call non-cash equivalent assets, which are ones that are tied up in retirement plans like a 401k, that dollar that is sitting in that account becomes equal to a dollar that's sitting in a bank account. And as we know, to take that money out, depending on the age of the spouses, there's number one, a penalty, and number two, there's taxes. So it's important that you equalize like-kind assets. In a negotiation, the parties may opt not to value the real estate, for example, if they're planning to sell and they'll use estimates. But again, if those assets are going to be sold, you don't look at them at their estimated value, you look at them at their net realizable value. Similarly, you're going to lump all the retirement assets and look at a distribution of all like-kind assets. If you go to court, and I think Natalie will talk about that, I think it's important, Natalie, for you to share your perspective on that issue when you go to court.
Yeah, so there's a couple things that I just wanted to point out. One is brokerage accounts. When you're dividing those brokerage accounts, you want to make sure that you're dividing them in kind, because there's tax treatment and basis that will attach to certain of the assets within the brokerage account. So you want to make sure if you're dividing it that everybody's getting 1/2 of the Apple stock and 1/2 of each of the holdings within the brokerage account. When it comes to equitable distribution and taxes, if you're going to trial, you never know what a judge is going to do. So after 30 years of practice, I've learned I go in and I'm asking for one thing and the other side is asking for something else. And then the judge does something that nobody asked for and you're basically stuck with it. If you don't present evidence of the tax treatment of each of the assets, even if you say, oh, judge, you know, there are capital gains if this property is sold. If you're not providing evidence of what the amount of those gains are, then the judge doesn't have anything to rely on when it comes to the valuation of that asset. So I really think it's best systematically to go through each asset and liability on your equitable distribution and think about any potential tax consequence or tax treatment with those assets and liabilities so that you can present the information to the court. Even if the asset doesn't ultimately get sold or the court determines that it's not appropriate to include the tax treatment, at least the evidence is there and the record is available.
And one thing I just want to add is, like, you know, rental property. A lot of people don't realize that there's a recapture on depreciation. And so sometimes that gets overlooked as to the tax effect on that. So that's something that somebody, you know, you want to keep an eye on if you have rental properties.
So in this example that Marta has just put up on the screen, what's important, the takeaway for me is that the likelihood of the court considering the tax consequence, for example, here are the capital gains, depends on how likely it is that the asset is going to be sold. So the easy situation is where the property is listed for sale, right? It's very likely the property is going to be sold. The judge really should include what the net value will be after all the tax considerations. But if, let's say, the business owner who's got a very successful business says, oh, but one day I may sell the business. And when I sell the business, here are the tax consequences. In an example like that, where it's really unlikely that a business will be sold, or it may be sold and it's so remote in time, it's too speculative for the court to include the tax consequence of a sale that may never occur or may occur sometime in the future. So if you think of it as a continuum, that will help guide you on the likelihood of whether the court will consider the tax consequence to that particular asset.
I even do that disclosure of the tax treatment if you've got spouses that in the middle of litigation are going to court requesting one or another property being sold. I will disclose the tax treatment of those assets in the footnotes so that the judge has the information available when he's making that determination.
And also maybe the costs to sell, meaning the,
yes,
the commission
net out,
and the
you'll
closing
net out the cost to sell as well as, or you'll footnote and
right.
the cost to sell the taxes so that you get to a net realizable amount.
So when it comes to executive compensation, I'm going to just tell you, you have to read the documents, because the documents will speak volumes about vesting, transferability, the reason for the award, whether it's for past performance, in which case it would be a marital asset potentially, or for future performance, in which case it may not be. So read the documents. Now, having said that, there are different forms of executive compensation, right? So we have 401ks, we have deferred comp, we have restricted stock, and each one of those has some nuance to it. In the year of the divorce, it is very possible that the executive compensation may be treated as income, and it also may be treated as an asset. So the reason why it may be treated as income is you may have a wage earner that's got $150,000 base salary, but based on some performance measures, may get double that or more in stock options and restricted stock. Whether those additional compensation benefits are included as income in the year of the divorce will be very specific as to whether they're exercisable, do they vest over a period of time, etc. So you've got to look at those issues. The other issue to consider is very often those interests may vest or be exercisable down the road beyond the period of the divorce, but they may be considered marital assets. If so, can the non-owner spouse receive their interest, even if it's contingent or vesting down the road, through the divorce, or do they have to be held by the owner spouse in a constructive trust? And we'll talk about that later, for future exercise. So looking at the documents will tell you whether those assets can be transferred. So stock options is also another form of executive compensation. And just because the option has not vested at the time of the divorce does not mean that it's not a marital asset. And so I think Tami's going to address the formula by which the valuation of stock options is calculated under Florida law.
So the purpose of this slide is the process of the way we are going to allocate the executive compensation, which may have both a marital and a non-marital component. The method in which we do this is through something called a coverture factor, which is expressed as the percentage of shares that earned during the marriage over the total amount of shares awarded. So we're not going to get in the weeds. I'm just doing an overview of how to do it. For example, in this situation, the husband was granted 5,615 shares of stock, which vests 25% per year. So the way we would attack this is we would do it in tranches. So the step one, we would break out the shares by the years of vesting. So we know there's 4 years that the shares vest. So we calculate the 5615 divided by 4. We have a line for each one. Then we calculate any fully vested shares as of the date of petition, because those are all marital. They've already vested, and those are marital shares. Then the remaining balance, which may vest in a future year or in 2 years, that's where the calculation I just previously discussed comes in. So once we do that calculation, what Natalie touched upon was the constructive trust. So the marital options, which have not vested, which we had calculated, should be held in a constructive trust. And once they vest and are exercised, the wife, because it has to be held by the husband, because they're his, in this scenario, his options. Once they are exercised, the wife will receive her portion net of taxes that she's entitled to under Florida law. And that is the way that we deal with stock options. So we're in time for polling question number 2. How many of your clients with stock options need to have coverture calculations performed? None, 1 to 5, 5 to 10, more than 10, or not applicable? And we'll give you some time to answer. So it looks like not applicable is 51%, none is 27%, 18%, 1 to 5, and 4%, 5 to 10.
Well, it sounds like this audience has very happily married clients.
Exactly. So the next section we're going to tackle is tax returns. So usually during an intact marriage, most married people file a joint tax return. In our firm, we do not allow one spouse to approve a tax return on behalf of the other. And we also require both parties to sign the return under penalties of perjury. We also have in place strict verification of both parties being involved in the tax process. So every year we have, as a firm, draft engagement letters for the tax returns, and both parties have to sign the engagement letter. We send the draft of the tax returns to both parties. And the most important thing is the Form 8879, which is the transmittal form, which we require both parties to sign, which gives us the authority to transmit their return electronically to the IRS. However, this is, like Natalie had previously said, in an ideal situation, that's the way it works. We all know that there are other firms out there that may not have these procedures in place. So what happens if one party claims they never saw a return, or they never signed the 8879, or they never participated, and one spouse did it? That's something that it comes up quite often. The underreporting of income during an intact marriage. Again, always remember you're signing your return under penalties of perjury that the return is accurate. If you are willingly underreporting income, the IRS can audit and penalize both parties with additional tax, interest, and penalties. So this is an area where we usually write into, or lawyers write into agreements, indemnifications, which Natalie's going to go into on the next slide, which deals with tax indemnifications to protect one spouse from another.
Okay, and before I even get to that, as you were speaking, Tami, I wanted to point out that when I'm representing the spouse who has not historically been involved in dealing with the accountant, reviewing the tax returns, but has sort of historically deferred to their spouse in that department, it is very common that the accountant will just assume that the consent that had been provided over years during the intact marriage just continues during the divorce time period. And very rarely have I had an accounting firm reach out to me and say, we know that your client is going through a divorce. Are they agreeable to us continuing to represent the couple jointly in the filing of the return during the divorce period? I try to send a letter affirmatively to the accounting firm if I'm representing the spouse that is not the knowledgeable spouse or the involved spouse, saying my client may agree to file a joint return, but without us being provided the return in advance, please understand that consent is not being provided, and that we would ask that you provide us with a joint return for our review sufficiently in advance. And then, hopefully everything is fine and it's not an issue. I know some accountants take issue with that, and it's not anything against the accountant, but when you have the spouse that's not knowledgeable, there are consequences to filing a joint return that exist in the divorce year that did not exist in the intact marriage period.
And as a firm, we have done that with attorneys. We have sent joint returns to attorneys going through a divorce, and exactly what Natalie had described. They have their person looking at it and come back with changes, but we do it well in advance, not on the due date.
Right. And so what happens when you've got the spouse will not sign a joint return? Now, the issue is kind of multifold. First of all, we offer, and if I'm representing the knowledgeable spouse, let's say, I will offer an indemnification agreement. The indemnification agreement obviously is not recognized by the IRS. They couldn't care less about that. And the indemnification agreement covers a few different contingencies. One is, if the income was derived during the intact marriage, I'm not going to agree that if there's additional taxes due, that my client is going to absorb all of the additional liability, because the income was derived and enjoyed by the parties during the marriage. What I will offer in that situation typically is if there are penalties or interest resulting from the inaccurate reporting of that information, then my client, who's the one with the knowledge, should be responsible for the additional taxes, not taxes, but the additional penalties and interest that may be attributable to the inaccurate reporting. The signing also will not be evidence that the non-knowledgeable spouse agrees with the accuracy of the reporting. For example, if you don't have that in your indemnification agreement, and now you've got the spouse that's not knowledgeable having signed off on the joint return, on cross-examination, the other lawyer is going to say, you signed this return under penalties of perjury. Obviously, you agreed that this accurately reported the income of your spouse. If you've got a separate agreement that says, not so fast because we're going through a divorce and I'm not necessarily agreeing to that, you offer the non-knowledgeable spouse an additional layer of protection from that type of situation. Finally, if you've got the recalcitrant spouse who still steadfastly refuses to sign the joint return, a court cannot force a spouse to sign a joint return. But what they can do is they can consider the financial difference between what would have happened if the joint return was filed versus what happens with a separate return. So if, for example, that resulted in an additional $30,000 of taxes, you can ask the judge to assess that against the recalcitrant spouse if there was no good faith basis for them to refuse to sign the joint return.
And we as forensic accountants actually do that calculation and put it on the equitable distribution chart for the judge to consider.
Okay, so let's talk about the hook or monkey wrench. And, I was saying earlier in the presentation that for years we had Robertson, which was our Florida Supreme Court case that made the issue of real estate very certain and predictable in divorces, right? Title controls. And if the non-owner spouse is added to the title of a non-marital property, it's presumptively marital. Well, then in 2017, the Florida Supreme Court threw in this monkey wrench and they approved the decision from the trial and appellate court, which basically stands for the proposition that your course of conduct and intent can result in the finding of donation of a gift, even where title is not transferred. So in this Hooker case, what happened is the husband in that case had some non-marital real property, and he, through the course of conduct, was found to have had the intention of donating or gifting half of the interest to the wife in the case. What did the court look at and rely on? Things like a postcard that he sent to the wife saying, honey, I hope you enjoy our vacation home. And the title to the vacation home was never transferred to include the wife. So this kind of threw all the family lawyers into disarray, because now you've got a situation that is ripe for challenging the non-marital status of real property if there are these kind of donative and course of conduct issues. I'm sure that the real estate bar was not thrilled with the outcome of that decision either, because it puts title at issue where before it seemed to be very well settled.
So now we're going to talk a bit about valuation concepts that are used in a marital dissolution case. And so we're going to start with fair market value, which is the standard of value under Florida law. And the definition really deals with a willing buyer and a willing seller. No one's forced to buy or sell, and they have knowledge about the relevant facts to arrive at a determination. Under Florida law, buy-sell agreements, just because someone has a buy-sell agreement in place, that doesn't necessarily mean that's considered the fair market value. They will consider them, but may not be the ultimate value. The treatment of capital counts and what those values are at a book value are also not typically considered fair market value. Regardless of what evidence gets put into the case regarding the value, typically there are three fundamental approaches that are used to try to arrive at that value, and that is income, market, and asset. And we're going to talk briefly about each one. Natalie, is there anything else you wanted to raise from a legal perspective on valuation?
No, what I would just say is you typically see this issue come up with medical practices. So a doctor has an interest in a medical practice and there's a buy-sell agreement. And when they're your client, they come to you and say, oh, my interest in the practice is nothing because look at my buy-sell agreement. So you can see how the court wouldn't be bound by that buy-sell agreement in determining what that fair market value interest is.
Good point. So the first approach we're going to talk briefly about is one relating to income, which is in many of our closely held client companies, they're service businesses, and therefore they're reliant upon this stream of income. So you can see that with the stream of income, a small change in the income can actually create a significant change in value. Typically, you're looking at what the earnings are. You're going to look at subtracting salaries. You're going to add back any of the perks that they've deducted so that you get to a reasonable cash flow. It includes goodwill. And the question becomes, how do we extract personal goodwill? We'll talk about that briefly where required. And again, it is a very sensitive calculation based on how much income is being generated.
And while Marta goes to the next slide, I just want to underscore personal goodwill in Florida is not a marital asset. So other jurisdictions allow for that to be considered a marital asset, but in Florida, based on our case law, that is not the situation.
That's correct. So oftentimes what you see is we will arrive at the various estimates of value under the approach, and we do not carve out that intangible asset, although in other jurisdictions that can be the case. Under the market approach, really what you're looking at is market multiples and the existence of market multiples with respect to those amounts. And you would look at either a revenue multiple or an EBITDA multiple, which is earnings before interest, taxes, depreciation, and amortization, and or net income. There are other multiples as well, but those are the ones that are commonly used. And again, multipliers make a big difference. So you can look at having as we talk about here in ag business, and the issue for these types of analyses are what are the comparable companies that you're using. You're looking at size, you're looking at niche, you're looking at their capital and debt structure, what kinds of clients they have. And typically those values always include a covenant not to compete. And the point here is that if you can't get good comparables, what it does become for the person doing the business valuation is the sanity check to make sure that the income approach is correct. As we talked about before, personal goodwill is not an asset that is recognized in the state of Florida, but in other jurisdictions it is. And there are models such as the multi-attribute utility model, which actually divides personal goodwill and corporate goodwill. And they have distinct characteristics, and the models attempt to quantify those distinct characteristics in the assistance of actually breaking out the amounts. The one thing I want to leave you with, and we'll talk about the asset method in a moment, but that it's really important is that there be a fulsome discussion with the person that is going to value the business as to the myriad of approaches within each one of these categories of the income, market, and asset approach to consider, because they can give you different results. Some of them are more appropriate than others, depending on the type of business it is. If it's a real estate property that you're dealing with, it's a very different methodology that you would normally see. If you're dealing with the valuation of a holding company, you often look at the asset method as compared to the income method. So you'd want to know those things because those certainly would factor into the determination of what approaches you select. For the net asset value method, you're going to be looking at identifying all the fair market values for all the assets and liabilities. And again, you need to be able to address the issue of pulling out intangibles where they can be identified and quantified. And again, in the state of Florida, you're not going to deal with personal goodwill.
And now we have polling question number 3. How many of your clients require a business valuation? I'm going to put it in the context of a divorce. None, 1 to 10, 10 to 20, more than 20, not applicable. And we'll give you some time to vote. And remember, these questions need to be answered for your CPE credits as well. So 41% not applicable, 18% none, 1 to 10, 30%, 10 to 20, 9%, more than 20, 2%.
Tami, people oftentimes tend to leave this issue to the side because they're at the beginning of the case focused on finding everything. And I think certainly the exercise of doing the process that Natalie described up front for equitable distribution is important. But you can't just leave that aspect of the case to the end, because that can be one of the most material assets that ends up becoming part of the distribution.
That could be the most valuable asset in the equitable distribution schedule.
That very well could be.
So can we have the next question?
Sorry.
So when it comes to the final part of analyzing your equitable distribution, we come to the division part of it. And typically after we valued everything, we've got our spreadsheet, and at the end, one party is going to owe the other party money. We call that the equalizer payment. Typically, there isn't the liquidity available to pay the equalizer payment. And so how does it get paid? Normally, once that amount is determined, there's going to be a payment schedule, which under Florida law needs to be within a reasonable period of time. So it can't be over 30 years. Generally speaking, you're talking about 5 years or less. There will be an interest component attached to the delay in receipt of payment. The range of interest, 3 to 4%, but that's fluctuating depending on what's happening, in the market. And when an asset cannot be transferred, then we reference in an agreement a constructive trust, which is not a trust like we're thinking of a trust document. A constructive trust is a legal fiction. And when an asset cannot be divided, but the parties are going to continue to own it together, this constructive trust acts as the owner spouse retaining for the non-owner spouse their beneficial interest in the constructive trust. And Tami, why don't you elaborate on that real briefly?
Sure. We often see cases where there are limited partnerships where it's very difficult and very costly to value their portion of their interests, and they usually have a low percentage of interest. So what we do is we put no value to it, we sign no value, but we put it in a constructive trust, which basically whoever is the owner on the account, owner of the K1 or whatever the asset may be, they would hold it for the spouse. And when cash needs to be contributed or cash gets distributed, or when income gets reported, everything gets done through the constructive trust so that both parties get equal treatment within that entity. And you have to take into account taxes as well, because each party has to pay taxes. So if it's held in, say, the wife's name, it has to be net of taxes when it comes out to the husband.
Okay, I know we're running out of time, so I'll just touch on spousal support. You should all know by now that it is no longer deductible. Effective January 1, 2019, no form of alimony is deductible unless it was pursuant to a court order prior to January 1, 2019. A lot of people have asked, what if you have a modification following January 1, 2019? If it's January 1, if the order was entered prior to January 1, 2019, then the modification would also allow for the alimony to continue to be taxable deductible unless the parties elect to opt out of that. Alimony, there's all kinds of forms of alimony, but essentially you have to look at the need and ability to pay to determine whether there's even a discussion of alimony. And then you look at imputing income based on the distribution of assets and liabilities in equitable distribution. That's why before you can even consider alimony, you have to go through the entire exercise of equitable distribution, because one party may be receiving investment property that generates income. That income will be a factor in any alimony determination. Retirement is a basis for modification if the retirement is at a reasonable retirement age and it's coupled with a reduction in income. So just hitting retirement age, if a party doesn't actually retire, is not in and of itself going to be a basis to modify alimony.
So we often have cases where there are minor children involved, and we as forensic accountants are often, we are asked to run child support calculations. And in order to calculate child support, there are numerous things that go into the calculation. So we need both parties' income. So if they both have compensation, that part's simple. However, if one party is underemployed or unemployed for whatever reason, but can work, and there's a vocational report out there, we may impute that income that the vocational report says on there as their income. If they are not going to work at all, we use minimum wage as the imputation of income, as that is the Florida law for child support. We also take into account who pays the health insurance, who pays the child care costs. We need the parenting plan, because that needs to be finalized so that we have the number of overnights each parent has with the child or children. So what happens when we have more than one child? Say we're doing this calculation for 2 children. So we do the calculation for 2 children, and in 2 years, one of the child emancipates. And so now we're down to 1. To save people from going back into court to do a modification, hiring an attorney, hiring all the stuff, what we now do is we do something called a step down if there's more than 1 child. So we then just basically take out that child and rerun the same calculation, but with 1 child. And then therefore it's already set forth that this will be the amount once the other child emancipates. Child support is always modifiable. It can be modifiable because one person is making a lot more money, or one person loses their job, or the parenting plan changes and there's no more visitation for one parent. There's a lot of reasons why, but it's always modifiable. Now, is child support secured by life insurance? If there's life insurance in place, most likely we would use the life insurance in place to secure child support. So that way, in case, God forbid, something happens, that child support's paid. Now, what if there's no life insurance in place? It's up to the judge, and they have discretion to make the payer obtain affordable life insurance. Again, the word is affordable life insurance. They can't make them go out and get something they cannot afford.
So Social Security is something that's often overlooked in divorce cases. And as you're seeing more and more older people get divorced, Social Security comes into play. So the earnings from Social Security are included in income on both sides, right? It's on the payor side, it's additional income if Social Security is being received. And on the recipient side, if they're going to be receiving Social Security, that factors in to reduce what their need is. The Social Security website, which I included on the slide, is very user-friendly. But basically, what I wanted you to take away is 1/2 of the spouse's benefits will be available to the former spouse, provided that they were married for at least 10 years. They have not remarried. They're 62 or older. And the benefit to be derived from the non-owner spouse is greater than what they were eligible for based on their own earnings history. Now, can the court require that a spouse apply for retirement benefits, Social Security benefits? The answer is, if the earner is at the maximum level of Social Security benefits, then the court can require that they apply. The court cannot ask them to apply if they're at the first point of eligibility, which will not realize their maximum benefits. One thing to consider also is putting in your marital settlement agreement, if it's appropriate, that the payor will apply for benefits once eligible or at a certain point in time, because that will affect the available Social Security for the spouse who is in need of income, who's going to be on the receiving end of that.
So who are you representing and advising is very, very important in the sense of information. So when we have what we call the in-spouse, there are a lot of advantages because they're usually the one in charge of the financial records and bank accounts. They know where everything's at. They have the brokerage accounts. They have knowledge about the finances, the spending patterns. If they're the business owner, it makes business valuations go much easier because the business valuator has access to the in spouse. When representing the out spouse, we may encounter a lot of more issues, and it's normal. They have never had prior or very limited involvement in any finances. So a lot of cases, some spouses do not even know what assets they have. They don't even know where they're held. They may just get a debit card or a credit card, and they don't pay the bills. So they have no idea what they spend. They usually don't have a good handle on their personal finances. And what we usually have to do is we have to educate them. And what we do is we do like a standard of living to show them this is what you spent once we get the documents. Now, obtaining the documents, when we have the out spouse, it's quite difficult because we have to do it through either mandatory disclosure or request for production, and we get the documents that way. Sometimes we have a conflict of interest. For instance, in our firm, if we're representing both the husband and wife in a joint tax return, we cannot represent either party in a matrimonial dispute. So even if they want us to, we have to ask them to waive the conflict of interest. Both parties have to waive it. So that will give us the ability to represent one or the other spouse. But most likely than not, in my experience, we usually become the neutral. So we represent both because they trust the firm, that we have the documents, and we will be the neutral. But again, we still need that conflict of interest waived, and we want it in writing. So that way, that gives us our assurance that we do not have a conflict.
So the other items that come to play in a marital dissolution case involve whether we can use information from the family office. Oftentimes, higher net worth clients use the services of a family office to track their finances, assets, liabilities, and it's a great source of information. Similarly, investment advisors may have an understanding of the tax basis of some of these clients and their assets, which becomes relevant again in preparing the equitable distribution. Both investment advisors and financial planners that are involved in helping them manage their finances are ones that you can get either information from, or for one of the spouses that really doesn't have a good understanding of the finances, or may think they do and find that there's more information, it gives them the ability to be able to speak with them about the information. It provides the professional team the data they're looking for. And then finally, the area of divorce coaches and mental health professionals and therapists, where those individuals really offer a structured, both emotional and process support for one or both of the spouses, and even sometimes the children as they're going through the process. So that concludes our formal comments. We do have some questions that are in our queue.
While Marta looks that up, I just noticed that my email address is not correct on the slide. So if you do have questions following this that you want to shoot to me, it's Natalie@llpa.com.
Great, Natalie, and thanks for bringing that up. We talked, I think, about the first one. In a domestic violence claim, how are the distribution of assets, liabilities handled? Is it any different? Does it depend on when the domestic violence started in the marriage?
Generally speaking, domestic violence is not going to impact the distribution of assets and liabilities unless, I mean, there was a case that I recall from a few years ago where the domestic violence included one of the spouses burning down the marital home. So obviously that had a direct effect on the assets and liabilities, but usually where I see it, it may have an impact on a support situations, because if there are, medical issues resulting from the domestic violence, but for that, you don't really see an impact on equitable distribution.
If the next question, Tami, if the home is a premarital asset with only one spouse on the title, is the other spouse still entitled to 50% upon the sale?
That is what we covered under the new 61.075, which was CA. And they do get some portion of the premarital asset. And if marital funds are utilized during the marriage, then there is that calculation that we have to go through.
And why don't you handle the one on child support, and then I have one more to ask.
Sure.
Child support, is that based on the age of the child?
It's basically the age of the child is usually 18 if they graduate high school, but if a child, for instance, graduates high school at 19, it would be 19.
Okay.
And
But
that's
child
all
support
written
is-
agreements.
Sorry, and child support is pursuant to the Uniform Child Support Guidelines. So it's not age specific. It's not different for an 11-year-old versus a 6-year-old or a 17-year-old, but the termination date is as Tami described.
Correct. And
And then if there's a special needs child, that's a whole nother situation where it could go beyond the age of 19.
okay. I wanted to get from, I guess from you, Natalie, your perspective on things you've been seeing as a result of the COVID pandemic. Have you had issues that have come up in your divorces that relate to the pandemic?
So, the biggest challenge is when it comes to looking at the value of businesses and the impact of COVID on income. Because, when COVID first happened, we thought, okay, it's a blip and we're going to kind of ignore it in our divorce cases because it's such an outlier and it's not a reflection and everybody's going to bounce back and it's only a matter of time. But the more removed we are from that, the more difficult it is to really evaluate what the long-term impact will be on certain businesses and income. For example, people that are in the retail business or the restaurant business or wholesale suppliers. Those industries are taking a big hit, and the time that it will take for them to rebound is so speculative at this point. So settling the case becomes a real challenge, because if you've got the business owner who's going through this downturn, they want to get it done yesterday because their business the valuation is so low. If you've got the out spouse, they want to drag it on because they're hoping that there will be a rebound and the trend will start trending up in terms of the valuation and income. So that has kind of put those businesses that are so directly impacted by COVID in this situation where it is a real challenge to try to reach common ground.
What about in terms of modification of support? Have you seen more individuals trying to modify?
So I personally, in my practice, is generally pretty high net worth people who are not so directly impacted. But if you look at the statistics with the, in the courthouse, the clerk's office, the incidents of modifications are definitely on the rise. I suspect that many of those cases are pro se people representing themselves because they don't have the means with which to hire lawyers to help them with modifications, which can be very costly very quickly.
Yes. Well, we want to thank all of you for joining us today. We hope you found it informative. We will put the presentation, we'll distribute that to you. And certainly if you do have any questions following our discussion today, feel free to reach out, and we'll update Natalie's email on the presentation so you'll have the correct one. So thank you so much again, and have a good afternoon.
Thank you, everybody.
Bye-bye.
Bye-bye.